Welcome to another American Bankruptcy Institute podcast. I'm Sam Gerdano, ABI Executive Director. It's the start of a new financial future for the financially troubled territory of Puerto Rico. Congress enacted the bipartisan PROMESA law this summer, creating, among other things, a financial oversight board. The 7 members of the board have been recently named by President Obama, and they have their work cut out for them. Puerto Rico has over $70 billion in public debt after years of financial mismanagement, political malpractice, and indifference from Washington. It's hemorrhaging not only red ink, but is suffering from an outmigration crisis, as thousands, U.S. citizens, have fled to the mainland in search of opportunities and a better life. With us today is an expert on the new law and a keen observer of the political and legal developments in Puerto Rico. John Mudd is an attorney and legal analyst admitted to practice in Puerto Rico, including the Puerto Rico federal courts, the First and Fourth Circuit Courts of Appeals as well. He received his law degree from the University of Puerto Rico Law School in 1982, starting his litigation career as an attorney in government practice, then private practice, handling a number of high-profile litigation matters. A solo practitioner for more than 10 years, John specializes in class actions, bankruptcy, constitutional law, mass tort litigation, and intricate issues of federal jurisdiction. He frequently gives seminars for continuing legal education credit, is a prolific blogger and commentator on the legal scene in Puerto Rico. For the past 4 years, he's studied, discussed, and written on the Puerto Rico debt crisis from both a financial and legal point of view. He was among the first analysts on the island to raise the probability of a congressional-imposed financial control board. So today we'll discuss the control board's power under the new law and the complex road ahead. So welcome, John, to ABI Podcasts.
Oh, thank you for having me.
So first, for those not as familiar with PROMESA, the product of a long negotiation, principally between House Republicans and the Treasury Department, let's start with the key philosophy, if you will, and key terms of the law. Why did Congress end up going in this direction, and what is PROMESA's promise?
Well, first of all, you have to give a little bit of background on what Puerto Rico is. Puerto Rico is an unincorporated territory of the United States. That's extremely important because PROMESA was put into effect pursuant to the territorial clause of the United States Constitution. What it means is that PROMESA, with the part of that has to do with the Fiscal Oversight Board, cannot be imposed on a state because of the 10th Amendment, of course. What happened here was that for years we've been having fiscal problems and economic problems, and this administration finally decided that in 2014 that it was going to make the local bankruptcy law because they decided that it would take too long for Congress to approve a Chapter 9 for Puerto Rico. They made the law, obviously, immediately that it was signed. The bondholders challenged it under Section 903 of the Bankruptcy Code. They won in district court, they won in circuit court, and eventually they won in the Supreme Court of the United States. That's very important. Because during the oral arguments of the case in the First Circuit, which is in Boston, which is the one that applies to us, the Judge Lynch, who eventually wrote the opinion, asked, what happened to Washington, D.C.? And the answer was, well, when Washington, D.C. asked for Chapter 9, they were given a control board. And immediately she said, oh, okay, that's okay. And so when you look at the opinion, you find that she basically was inviting Congress to do that. The Supreme Court didn't get into that, but the First Circuit is very important because any appeals which are limited in PROMESA will go to the First Circuit.
Right.
Now, what happened then was that when it was obvious that Puerto Rico was not going to get, and we're talking by the time the decision by Judge Pesosa, who was the district judge, who decided originally the Recovery Act. I read the opinion. Anybody who read it knew that the judge was right. Okay. Immediately that happened, which was February of 2015, Puerto Rico started, and the Treasury Department of the United States started moving for some type of bankruptcy for Puerto Rico. Congress said, no, I'm not going to give you a bankruptcy. Republican-dominated Congress. No, I'm not going to give you that one. I'm going to give you this fiscal control board. And it went back and forth until they finally decided, you know what, you want a fiscal control board? I want bankruptcy. Let's agree to disagree, and you get this and you get that. And they filled in the blanks. The law is not the greatest thing in the world. It's not that either. It's just there, and I think it's quite obvious that certain parts of the law will depend how they'll be used. Will depend on how the board members look at it.
Right.
To go directly to, I think, the most important parts in terms of bankruptcy, etc., is that immediately that it was signed into law, a stay applied. That's under Section 405 of PROMESA. The stay basically applied to any procedure that could have been filed before PROMESA was enacted and that asked for a payment of any kind of bond. Okay. Shortly before PROMESA was enacted, there were several cases that were filed, and eventually Judge Vest, also the same one that dealt with the Recovery Act, decided, you know what? Yes, the stay applies to you. It was surprising to me because those cases were not actually seeking collection of monies, but that's what he decided. But he said at the same time, okay, the stay can be lifted, and this is very important. The stay in bankruptcy, as we're all familiar with, is the norm and not the exception. The court has to say, okay, I'm going to lift the stay in order for you to be able to do anything. Even if you ask for it and the judge doesn't give it to you, well, you don't get it. In PROMESA, however, if you ask for lifting of the stay and 45 days expire from that date, the stay is automatically lifted, which makes me think that the stay is, as I said, not the norm,
right?
The exception. Okay. Very importantly, the stay will expire by February 15th. The board can extend it for 75 more days, which could be May the 1st. Cannot extend it for any other time. There's another type of extension that I'll discuss in a minute. Once we discuss the stay, that stay was done, of course, so Puerto Rico could voluntarily continue the discussions on some type of agreement with the bondholders.
Right.
Now, if you look at the press, Puerto Rico government was telling the press that they had been negotiating with the bondholders for years, but Melba Costa, who was the chief financial officer of Puerto Rico, when she testified, or was forced to testify actually, in the Walmart litigation in January of this year, February actually, she was asked point blank, isn't it true? Because I can say this because I was there. I heard her say that, and then I read it in the transcript. Isn't it true that the first time Puerto Rico sat down with its bondholders to negotiate was on January 29th, 2016. And since she didn't want to get put in jail, she said yes. So we see that there's a dual story here. Several of the advisors of Puerto Rico, including somebody well-respected like Jim Milstein, kept saying, no, we're negotiating, but they weren't. Because Melba Costa was not going to lie, much less to Judge Fuster, who was the judge there, who would put in jail anyone who did something he thought was wrong. He had no qualms about that. Okay, continuing. Subsequently, of course, there have been negotiations. And actually, we know that by June the 20th, certain general obligation bond holders offered Puerto Rico 89 cents on the dollar to reduce their indebtedness. Puerto Rico had offered 81 cents. And I admit that I've never negotiated billion-dollar deals, but I've negotiated quite a few million-dollar deals. And when you're that close, what you usually do is you split the difference,
right.
85 cents. And that could have solved everything. You would have about $18 billion knocked out or just, dealt with. Bondholders are telling me, and nobody is telling me anything different, that after that there have been no negotiations. So it seems that Puerto Rico has wasted July and August and part of September in actually doing nothing. Although Mr. Milstein's contract was renewed in August for $8.8 million until June of next year. Okay, that's neither here nor there. The point I'm trying to make is that although Puerto Rico is supposed to negotiate the agreement, they're not doing it. But let's assume there's a negotiation. What happens? Well, you go to Title 6. Title 6, Chapter 600 and so on forth of PROMESA. It gives you the details, but essentially it says if you have a qualified modification, you're modifying the bond or whatever indebtedness it is, and you present it to the board. It could be Puerto Rico or it could be a bondholder who presents it. And the board says, you know what, that's a good one. Let's vote on it. The board decides if there's going to be a vote on it. And those decisions are unappealable because it's a certification. Everything that says in PROMESA certification is non-appealable, and the Supreme Court of the United States has said that Congress can do that as long as it makes it very clear it's unappealable. And the law says clearly it's unappealable. So what happens is that when you vote, if you have 2/3 of the vote in favor of those who have the right to vote, then you go to federal court, federal district court. Federal district court reviews to see if the due process has been done and says, okay, we agree, we approve, and that's the new indebtedness. Okay? But what happens if you don't have an agreement? Or you have an agreement and for whatever reason Puerto Rico couldn't pay? Well, then you go to the board, Puerto Rico government, not the board. You go to the board and you say, sir, can I go into bankruptcy? Sounds like, Oliver Twist.
Right.
And the board is to certify. That's under Section 206. And you have to certify that the entity does not have to be insolvent because that's part of Chapter 9.
Right.
Let me make a little parenthesis here. Title 3 is the part of bankruptcy. Okay. What they actually did was they took some parts of what is done in Chapter 9, but not all of it,
Right.
and they put some little different things. But we'll go into details into that in a minute. Okay. But the board does have to certify and find that there has been good faith negotiations. And that's a problem because right now there have been no negotiations.
Right.
The last couple of months. But let's assume that there has been good faith negotiations, etc. Then the board, not Puerto Rico, files the petition.
Right.
Okay? The board can amend the petition, not Puerto Rico. And finally, under Section 314, which is similar to 1129, because Section 943 was not adopted. But parts of Section 1129 were adopted, very importantly, 1121b1, which is the cram down. That is part of the law. So you have to consider that in any bankruptcy, in this special bankruptcy law, the court may cram down in the same way it would do it in a Chapter 11.
Mm-hmm. So that's important.
That's extremely important.
For our people to understand many parts of Chapter 9 have been imported into PROMESA under what is Title 3 of the law, which is the non-voluntary procedures.
Mm-hmm.
And that requires, again, a supermajority vote of the 7 members of the board.
Yeah, you need 5 for the certification. That's very important. I forgot about that. And later on we'll talk when we get to the members of the board.
Right.
The importance of those 5 votes. Going back, once it is approved, if the plan is approved, you go as you go in any Chapter 11 or Chapter 9. The couple of interesting provisions in all of this is that under Section 314, the bankruptcy plan has to comply with the fiscal plan, with Section 201 of PROMESA. The fiscal plan has a little interesting little tidbit, and a lot of people have not looked into it. I have to bear with me for a second here. I'm going to my copy here of 201. The fiscal plan has to respect the relative in the Constitution, respect the relative lawful priorities or lawful liens as may be applicable in the Constitution or the laws or agreements of a covered territory or covered territorial instrumentality in effect prior to the date of enactment of this act. What does that mean? We'll get into a second. Now, if you have to respect the plan, and the plan has to respect that, does that mean, for example, that the general obligation bonds, which under Puerto Rican law have to be paid, or as I believe, the whole of the public debt under Article 6, Section 8 of the Constitution, that you have to pay the public debt first before you pay anything else? Does it mean that you have to comply with that, or does it mean that you just have to, look at it and say, well, yeah, we should, but we can't, so. And I don't really have an answer for you. But the report by the Natural Resources Committee on PROMESA has a very interesting part when it talks about Section 314. It actually says that we have incorporated here that they have to respect the relative level. What I just read on Section N of 201. So it gives you the idea that you do have to comply with that law, but if you look at what actually happened, was that every time a Republican tried to say you have to give these priority, those amendments were shot down. So it's like in tennis, advantage GOs, but it's not for sure that way. Mm-hmm. It may bring in enormous amounts of litigation.
Right. So we wanted to talk about the board's powers. They are broad, certainly. And now that they're
at the same time so narrow.
Now that they're in business. But they are to work with the local government. So kind of explain that, their interface with things like budgeting and the role of the political branches of government with the board. Obviously, in Congress, many were concerned that the board would exercise perhaps heavy-handed power. There was lots of talk of paternalism and parochialism, and there were a lot of concerns about respecting the local prerogatives here. So explain a little bit about how the control board is supposed to interface with the local government with respect to budgeting and financial decisions.
Okay, let's go first. A little bit of background on Puerto Rico again. Puerto Rico is a territory. Okay, Puerto Rico had, until PROMESA was enacted, the full powers like any other state. You look at the First Circuit Court opinions. Puerto Rico's like a state. Puerto Rico's like a state, and they continued saying that, forgetting that Puerto Rico is a territory. Okay, then this term, in the case of Sanchez Valle, Puerto Rico versus Sanchez Valle, went to the Supreme Court of the United States from the Supreme Court of Puerto Rico. The Supreme Court of Puerto Rico said, for purposes of double jeopardy, Puerto Rico is a territory, and therefore it's part of the federal government, technically, and there's ample precedence to that. Therefore, if the federal government accused you of something that has the same elements of the law in Puerto Rico, and you were found guilty, in this case they pled guilty, you cannot be tried again. And the government of Puerto Rico, which didn't agree with that decision for political purposes, went to the Supreme Court, and the Supreme Court basically did a really bad number on Puerto Rico, and said that Puerto Rico is, for practical purposes, a territory. Why is that important? When you look at the territorial clause, it says Congress may dispose of, and I want to stress dispose of. That means tomorrow, if Congress wanted, Congress, not the president, it could basically give away Puerto Rico, and that's the way it is. And the other part of the territorial clause says, or make needful rules. Okay. Subsequently, from the invasion in 1888, there's a case called Downs versus Bidwell, the Supreme Court of the United States, and they said basically, well, Puerto Rico is part of, but not of the United States. Basically, kind of weird thing. And said something also very important, which is repeated later on in other cases. Congress can do whatever it wants except on fundamental rights. So our fundamental rights are protected. What they are, that's not right. Now, going to 201, PROMESA. PROMESA basically is to improve the fiscal situation of Puerto Rico and get it into the market in a way that it can borrow money.
Right.
Okay? So the main powers of the board are two. One is the fiscal plan. The board, not Puerto Rico, the board will tell Puerto Rico, okay, I want a fiscal plan this way, okay, not any other way. The law sets about 10 things that PROMESA must have, the plan, I'm sorry. But it also has a little part that says whatever the board thinks is needed. Okay? In that sense, the board can say, we want this. And if Puerto Rico doesn't provide it and doesn't give in the fiscal plan what the board thinks it needs to do, they can say, well, you got to change it. And if Puerto Rico doesn't change it adequately, the board can impose its own fiscal plan. Okay? Second, the budgets. Budgets every year, the budget will be provided. The budget by the governor will be provided to the board. The board will say, well, we agree with it, or you don't agree with it. And if you don't agree with it, well, you have to change this. And if you don't do it the right way, we change it the way it should be done. The board can go to federal court and do whatever lawsuits it needs for it to make Puerto Rico comply with its laws. In other words, Governor, well, you're violating, you're not giving me the budget, and you're doing the budget your way. Federal court, do something. The federal court can come over and say, you know what, Governor, if you don't do it, I'm going to put you in jail. And they will. The judges here are very strict. More than once, it has told members of this government, either you comply with what I'm asking, or you come tomorrow and you bring your toothbrush. And I'm serious. They've said that.
Right.
And in the past, Judge Rosted, I mentioned before, I know put in jail the whole legislature of a municipality because they wouldn't approve the payment of some judgment. They said, okay, no problem, I'll put you in jail. And he put him in jail, I think it was for 2 hours, and in 2 hours they said, yes, we'll do it. Okay, those are the main I would say, tools. There's another important tool that is not looked at very much, but it's also very important. The board can make suggestions.
Mm-hmm. Right.
And it's like in The Godfather, make an offer you can't refuse. Same thing. The suggestion, if Puerto Rico says, no, I'm not going to comply with that suggestion, well, you have to tell me why. Literally, you have 90 days to tell me why not. And you don't tell me only. You got to tell Congress. So the premise there is that if you don't do what I'm telling you, you know what? I may ask Congress to do it for you.
Right.
Then there's another thing, which I have to go into one particular member of the board who's an expert in bankruptcy and what he has written about in order to get into this other tool that the board may have. David Skeel is a professor in Pennsylvania, Pennsylvania, in corporations and bankruptcy. Now, Mr. Skeel is well known for advocating bankruptcy for the state.
Right.
Okay? And one of the things he says in an article in 2016 actually says basically municipal governance and the role of municipal bankruptcy in changing that governance. What he's advocating in those articles is that in the bankruptcy plan, you put the changes of governance that are needed, and the judge, and he has a point, can basically blackmail you into doing it. Oh, you don't want to do that? No problem. I'm not going to approve the plan. And then what do you do? Interestingly enough, there's about 3 parts of Chapter 9 that he says create a problem for this. But those 2 have not been adopted to PROMESA. So it is conceivable that Mr. Skeel may decide it's a good idea to change the governance in Puerto Rico, which is definitely needed, by telling the government, you want bankruptcy? No problem, but you have to change this, and that. And force those changes into the bankruptcy. That could very easily happen.
Right.
Or even if they're not, the changes are not accepted, since the board is the one who actually files the bankruptcy claim, it could be done.
You mentioned Professor Skeel is obviously well known to our members.
Yes.
He served a stint as our resident scholar here and has spoken and written on a number of ABI programs. Also on the board is another person very familiar to our members, and that's Judge Gonzalez, who was at one time the chief judge of the Southern District of New York Bankruptcy Court, presided over many important matters, and also served as a member of ABI's Commission to Study the Reform of Chapter 11. So there's at least two, I would say, bankruptcy experts on the board. In terms of the other folks on the board who wouldn't be so familiar to our members, what can you tell us about them, and do any of them had a predisposition one way or the other about how to solve kind of the financial problems that Puerto Rico is facing?
I'll go into that in a second. I want to make emphasis on Arthur Gonzalez. I had the pleasure of dealing with him in the Enron litigation. He's really knowledgeable, etc. Mr. Skeel makes reference to the Chrysler bankruptcy as another way of, in a Chapter 11, making changes to the governance. And we all know that
that was Judge Gonzalez's
case. The judge in that case.
Right.
So, let's look at the other five members. You have, I'm going to go into the Puerto Rican. You have Carlos Garcia. Carlos Garcia used to be the president of the Government Development Bank, who is the fiscal agent, or was the fiscal agent of Puerto Rico.
Right.
He was involved in the issuing of some of these bonds, and some people are saying he has a conflict of interest, all that stuff. But the problem is that he was appointed by the president, and the president is the only one who can remove him, and he has to remove him for cause.
Right.
He knows a lot about Puerto Rico. That's just good. Then you have Jose Ramon Gonzalez, who used to be president of the Government Development Bank back in the 80s, a man who has vast knowledge in Puerto Rico. Interestingly enough, these two, Garcia and Ramon Gonzalez, worked in Santander Securities for a period of time, and to my knowledge, they got along fine. They're from different parties in Puerto Rico, but they were, they got along well. Then you have the third Puerto Rican, whose name escapes me right now.
Carrion?
No, Mato Santos. Carrion. Okay.
Yeah.
Carrion is an executive and very well-known man in terms of insurance.
Mm-hmm.
Why is insurance important? Well, some of the bonds are insured, and it's an important industry in any state of the union. And his expertise in business is going to be used. Okay, so we have those three. We have knowledge of Puerto Rico, and we have important knowledge of it. Then we go into what is my favorite, Ms. Mato Santos, Puerto Rican origin. Her family's from here, but she apparently she went to Stanford and stayed in California. She was the budget officer for Mr. Schwarzenegger and Mr. Brown, which are two extremes in politics.
Right.
But it was needed at the time. You can summarize her that she cut and she cut and she cut the budgets all the way. And that's useful. We need somebody like her to look at the bloated bureaucracy in Puerto Rico and say, you know what, we just have to really cut it, and give us ideas on how to cut it. And I think she is the type of technocrat, and I say it in that admiring way, that this whole mess needs. And then we have a Mr. Biggs.
Right.
Andrew Biggs, interestingly enough, is an expert, and he wrote a report for the Society of, oh my God, I always forget the name of, it's Actuaries, the Society of Actuaries. And he wrote a report on the issue of lack of funding for government pensions. That was back in 2014. He has written, I think it was in Fortune magazine in March, he said that the Puerto Rico retirement fund was badly managed, which is like, yeah, we know, and that there was a lot of changes that needed to be done. Tying that into bankruptcy, like many states in Puerto Rico, although it's not written constitutionally, it is a decision of what's called by Don Toro. The people who are retired, who receive retirement funds, have a constitutional right to be paid. Okay, but obviously in bankruptcy, that constitutional right, which is state right, can be overridden, except for what I read about, respecting the different standards, constitutional, blah, blah. So that can be changed through bankruptcy. I really don't see how you can fund the Puerto Rican bank pensions right now. I think they have the central government's pension fund right now has less than 1%. To give things into perspective, if you take that retirement fund and you take the teachers' retirement fund, and teachers don't pay Social Security in Puerto Rico, so the only income they have when they retire is from the pension.
Mm-hmm.
If you take those two together, Puerto Rico will have to come up with $2.2 billion in order to substitute for the payments that are being made by the pension plan.
Right.
So you have those. The group is eclectic, but it, I think, does deal well with actually what's needed in Puerto Rico.
Mm-hmm.
We need change, period.
Right.
Fiscally, socially, etc.
A couple of other interesting things, John, which I know you know, is that the members of the board serve for 3-year terms. They're removable only for cause, as I think you mentioned. They also serve without compensation. So this is a big job.
Yes.
But they're essentially volunteers.
Yes.
There are some other. There's a power to appoint a staff executive who is paid, and some other administrative personnel as well. But so their work begins, and it begins, and this is maybe the last thing I'd like to raise with you is there's a backdrop of outstanding litigation which is ongoing.
Yes.
And so maybe let's just talk a little bit about that.
Yes.
Judge Besosa, the federal district court in Puerto Rico, recently refused to stay one of the bondholder suits. So,
well, actually, he didn't. He refused to stay 3 of them, and there's another one which filed recently that wanted to join in a hearing. Because going back to the whole thing, Judge Besosa said, "Okay, I'm not gonna. The stay applies to you guys, although they weren't asking for money, but the cases were filed before, or could have been filed, and were filed before PROMESA. But I'm going to give you the opportunity, because the law provides for that, for the lifting of the stay. Now, the hearings on the lifting of the stay, and there's 4 cases on that, will start on September 22. Okay." And interestingly enough, Judge Besosa, like everybody else in the federal court system, has a big load of cases. Recently, one of my cases, which is with him, I have several with him, was sent to a judge in Rhode Island, which is not unusual, but usually it's like huge cases. So it seems that the federal court system understands that Judge Besosa is really up to his neck on these things, and he needs time to deal with them. So they're giving him a break, which is, again, a good idea. I'm not complaining, although I like Judge. I like dealing with him. He's a no-nonsense guy. Those hearings will determine one of 2 things. Either he raises, well, actually 3. Either he raises the stay, either he doesn't raise the stay, or he raises the stay for some cases and not in others. As I said, there were at least 4 that are going to those hearings. Interestingly enough, in another very important case, which is filed by Lex Claims and others, their general obligation holders, the judge decided, you know what, PROMESA doesn't apply to you. Why? Because you filed after PROMESA, you filed based on PROMESA, a violation of Section 204C3. It's very important. Basically saying that you have changed the constitutional priority of payment. Now, whether that's true or not, that's not a matter. But he said, the stay does not apply to you guys. And there will be there's already a motion to dismiss, and I think it's by the 30th. Lex Claims has to oppose it. I'm sure they will oppose it, and then the judge decide whether the government of Puerto Rico violated PROMESA, which personally I think they did.
Finally, what given the fact of this ongoing litigation is the backdrop of the board's initial action, what's your kind of short-term prediction on the first things that the board needs to do? I mean, they're not involved in the stay litigation, but it certainly could have an impact on their work if the court rules one way or the other. So, putting that aside, what do you think is the first thing that the board needs to get working on as they begin their work?
I would say that the first thing the board really needs to do is find out exactly what type of negotiations, if any, are being done right now, at what stage they are. And they need to know that like yesterday.
Right.
Why? Well, let's just suppose that what the bondholders tell me is true, and that there are no negotiations. Well, the board has to say, hey, you gentlemen, you better get your in gear.
Right.
Or if it's going on, I think that the board should make a statement. I think the board has to be transparent, has to give people information, has to be in the social media, etc., and say, hey, this is going on. We're keeping an eye on it. We're confident something's going to happen. Okay, something positive, I would say. People in Puerto Rico need hope. They really need hope.
Right.
That's the first thing. Second thing is under 204C3, there's several actions by the government of Puerto Rico, which I personally think violate PROMESA. I think the board has to look at it and see if they think they have violated it, and if they think they should do something about it.
Right.
They may not want to do something about it for strategic reasons, but they need to do that. And I want to make a little footnote here. The government of Puerto Rico has said several times that it is going to present the fiscal plan in the next few days. Mr. Ravitch,
yes,
who is a member ex officio of the board,
right,
designated by the governor of Puerto Rico,
right,
has said that, I think it was yesterday. Now, that is not what the law of PROMESA says. Not only that, but what I think they're doing is that the Treasury Department is pushing for that, because the Treasury Department is pushing for bankruptcy. Now, why is that important? Because the law text specifically states that no entity can go into bankruptcy unless it has a fiscal plan in place.
Right.
So, if they present a fiscal plan and the board accepts it, which is always a big if, it would be a lot quicker than if the board asked for the fiscal plan, given the fact that there is going to be a change of government, no matter what, in November.
Right.
In November, we have elections like
right.
in the States, and there will be a new governor.
Right.
So anybody in their right mind would say, let me wait until the next government is elected.
Right.
And then I'll do that. But then there cannot be any bankruptcy until you have that approved, and it will take longer.
Right.
On the other hand, why would you approve any bankruptcy unless you really know what the numbers are? And that takes time. The government of Puerto Rico is very opaque in its information.
Right.
It has no Freedom of Information Act. If you ask for something as simple as, can you give me the names of the bondholders, people had to sue here to get those lists.
Well, there's a lot ahead, and we've really just scratched the surface on PROMESA. We'd love to have you back, John, to follow up with the board's progress in the months ahead, particularly after the new administration takes effect at the beginning of the year.
And by the way, I want to your listeners, it's very important for everybody in the bankruptcy bar in the United States to understand that there will be huge amounts of litigation here, okay, that will involve bankruptcy. And our bankruptcy bar is very small.
Right.
We have never had a Chapter 9 in Puerto Rico for two reasons. Before 84, simply because the laws of Puerto Rico did not allow for municipalities to go into bankruptcy.
Right.
And after 84, well, we were not allowed to go to Chapter 9.
Right.
So we have no one here who has actually dealt with them. So there will be a need for people, okay? Obviously, there's a lot of people here who are very knowledgeable in bankruptcy, myself included, but we've never dealt with the Chapter 9 in reality.
For sure. Well, thank you, John, again, for sharing your thoughts on the background and history and up-to-date developments in terms of litigation down there. We also thank our audience, as always, for listening. Remind you that there are nearly 200 podcasts online at abi.org/newsroom/podcasts. And so until next time, then, this is Sam Gerdano for the American Bankruptcy Institute saying good day.